To please the court, we're before the court this afternoon in the matter of the State of Ohio versus Catherine Belcher, case number 25 CR 1154. The defendant is present in the courtroom with her attorney, Rachel Smith. We're before the court for purposes of sentencing, the defendant having pleaded guilty and been found guilty of 1-count felony of the 3rd degree aggravated possession of drugs, 1-count felony of the 5th degree possession of cocaine, 1-count felony of the 2nd degree robbery. Parties are ready to go forward, Your Honor.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Ms. Belcher is asking the court to impose a minimum prison term here. Ms. Belcher appreciates the seriousness of the injuries that her mom suffered as a result of the instant offense. Ms. Belcher acknowledges a long history of drug abuse and difficulties conquering that. Although she has struggled in the past, this is her first felony conviction. She's never been to prison before. Ms. Belcher is aware that her acceptance of responsibility and show of remorse perhaps did not come through as clear as intended to her pre-sentence report, and she does have a letter here to read to the judge today.
Thank you. Ms. Belcher, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, Your Honor. Firstly, I would like to thank Lake County officers, the Sheriff Department, and you, Judge Collada, for granting me a moment to sit and reflect on my mistakes. At first, I didn't understand, but God has granted me the new vision to see my life through a different lens. Because God placed you into my life, I didn't go septic and die in jail. Thanks to the jail and sheriffs for transporting me each week, I have my health back. Thank you so much for this, Your Honor. I've been selfish for many years, allowing my addiction to completely take over my soul, and I realize now that my actions were so selfish. I genuinely would like to apologize to my family and friends, and mostly my mom, because she's all I have. My dad, after my dad passed, I have not only let myself down, but my children. I think today was the first selfless act I've done. I asked them not to come because I didn't want them to watch their mother or cause any of them any more pain. I feel deeply. It just wouldn't be right. My heart would completely break for them to have to watch me go to prison as well. I will absolutely do every ounce of time God sees fit for me to do. Your Honor, I come to you today with an open heart. I trust that you will grant me understanding with hopes that you see fit, that one more opportunity is granted so I can fix this and show not only myself, but my family and you that I am bigger than an addiction, and please give me one more chance. Thank you so much.
Thank you. Shapiro for the State of Ohio.
Thank you, Your Honor. First, I'd like to, pursuant to the agreement between the parties, that the court order that the defendant pay $100 restitution to Mr. Robert Taylor, Taylor. This is an agreement that between the State of Ohio and the defendant. This is a car that the defendant struck that night, caused some damage. This is Mr. Taylor's deductible. The state dismissed count 16. It's a misdemeanor in the first degree with the understanding that that would be ordered. So we would ask that the court please do that. Defendant has a drug problem that she has never dealt with, and that exacerbated the offenses here. Maybe it's the root of it. I don't know. Looking back at her criminal history, she has a domestic violence from 2001, and so she does have something other than drugs in her past. I mean, she has a misdemeanor drug offense as well, but some theft charges. These are convictions that are common in people who are convicted of drugs, who steal. But the defendant's 39 years old, hasn't gotten any help for it, and it culminated in her robbing her mother. She was a 71-year-old elderly lady. Whether she was drinking that night or not, she didn't deserve to be robbed and pushed down and get broken ribs. The injury in this case is serious. And I think that differentiates this case. Yeah. Criminal history, well, there's no felonies, there's a pattern of. The state believes that a overall conglomerate sentence of 5 years is an appropriate number of years for the court to impose on the defendant for all of this conduct combined, Your Honor. The defendant does have credit for 93 days. And the state would ask for, pursuant to the agreement of the parties, forfeiture of all of the contraband drugs that were taken in the packaging as by agreement.
So that is just drugs and paraphernalia we're talking about.
Yeah, there was some items that.
But no other property, no phones or money or anything like that.
There was some other stuff that was recovered. Yeah.
I received a victim impact statement. I've considered what's been said here in court today by Ms. Smith, the defendant, statement that she read, the prosecutor, the recommendations from the parties. All of this is considered by this court in light of the purposes and principles of felony sentencing set forth in 29, 29, and 11 of the revised code. For the factors in 29, 29, 12, in regards to count 1, I am going to note that the defendant's son was in the vehicle with her when these drugs were found and the pipes were found. That makes it more serious. And the son's an adult. I don't want to mislead it. It's a minor, but nonetheless, it's a 20-year-old son in the car with her. No other factors are present regarding the offense being more or less serious in regards to count 1. In regards to count 9, the court finds that the defendant's relationship with the victim facilitated the offense. This was her own mother. That the victim suffered serious physical harm, and that injury she sustained was exacerbated due to the age of the victim being 71 years old at the time. As for recidivism factors, the court finds the defendant was on probation at the time she committed the offense. There's a history of criminal convictions, albeit no prior felonies, but a lengthy history of criminal convictions. She's been on probation before in the past. She's violated her probation on multiple occasions in the past, so she has failed to comply with previously imposed sanctions ordered by courts. And every factor is present indicating recidivism is more likely. There's a drug abuse problem that relates to all 3 offenses, and she hasn't done anything to address it. As for the robbery charge, there's no genuine remorse. None. In fact, she basically denies doing it. When she met with the probation department, she told the probation officer, and this is a written version, that she's scared that her mother might have fallen down the stairs and is embarrassed to say anything, and that's how she got injured. She then told probation that she denied ever hurting her mother, said she only grabbed her wrist and pushed her out of the way so she could leave. She indicated she's okay with doing time for something she did, but does not feel she's done anything and she's being, quote, railroaded in this case. And she's taking it, those are her words, so her mother doesn't have to go through this anymore. There's no acceptance of responsibility in terms of the robbery charge and what she did to her mother.
I was going.
What's that?
I wanted to apologize. I was going through a lot.
You're going through a lot.
Hearsay. I was told my kid's father passed away, and I was going through some stuff, and I didn't get to finish my pre-sentence report.
You finished your pre-sentence report. It's completed.
No, I didn't get to write everything. That I was fully accepting my mistakes, that my addiction caused whatever circumstances happened.
Who prevented you from doing that?
No, I was not being myself.
So you were given the opportunity to do it.
I know, and I wasn't doing it right. I wasn't being truthful, and I was just angry. And this should have never happened.
It's been 180 days in jail so far. It wasn't like you were still under the influence of anything the time this is going on.
No, I meant for my addiction affected the relationship between me and my mother and the outcome should have never happened.
I understand that. I'm saying that when you met with probation just within the last month, you still didn't accept responsibility. You still blamed your mother. You said it was her fault, or she may have fallen down the stairs and hurt herself. You didn't do anything. Now, the day you're sitting here waiting judgment on what's your future, what's going to happen, is the first time we're ever hearing anything that you're saying you did something and you lied and that you are responsible. Well, I don't accept that.
Okay.
When you're sitting before the judge who's about to pronounce sentence, and that's the first time that you come forward accepting responsibility, when you had multiple opportunities before to accept responsibility and you didn't do it,
Right.
that's not genuine remorse. This is your own mother. Even with the drug charges, you don't accept responsibility. You say it's all the person that was in the car with you. He's putting it all on you. You admitted in the other drug case having heroin, but denied the methamphetamine all was yours. I mean, they're just denials. So every factor indicating recidivism is more likely is present. There's no factors present indicating that recidivism is less likely. 9 are subject to a presumption for prison. The presumption is not overcome. No way the court can make any finding that the factors indicating recidivism is less likely outweigh the factors indicating it's more likely. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Therefore, it will be the sentence of this court. And count 1, defendant serve a term in prison of 12 months. Then count 6, defendant serve a term in prison of 9 months. And then on count 9, defendant serve an indefinite prison term of a minimum of 5 years, a maximum of 7.5 years. The 3 counts will be served concurrent with each other for an overall aggregate of an indefinite term of a minimum of 5 years, maximum of 7.5 years. She has credit for 93 days. She's already served. Those will be granted to her. I order the forfeiture of the contraband and instrumentalities, the drug-related paraphernalia and drugs themselves. All the remaining counts of the indictment will be dismissed pursuant to the agreement. I'll order restitution as agreed to Robert Taylor in the amount of $100. I need to advise you upon your release from prison, you will be placed on post-release control. It's mandatory for at least 18 months. It could be up to 3 years. While on post-release control, if you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. And there is a rebuttable presumption that you will be released from that prison term after you have served the minimum sentence that I imposed, the 5 years. Now, while there's a rebuttable presumption, that doesn't mean it is guaranteed. If while you are in prison you misbehave, you don't follow the rules of the institution, you remain a threat to the community or others, or not sufficiently rehabilitated, the prison officials can schedule a hearing, which you'd be entitled to be at. And at that hearing, if they demonstrate that in fact you aren't sufficiently rehabilitated or remain a threat or committed violations of the rules, they don't have to let you out at that point. They can keep you in prison. They would select a new date that you'd be released with the presumption that you'd be released on that new day. And you would have to be released on that new date unless, again, you continue to misbehave, remain a threat, not be rehabilitated. If that was the case, they'd postpone the release date again. Under no circumstances, however, can you be kept in beyond the maximum sentence. So even if you misbehave the whole time you're there, they have to release you at the end of the maximum sentence. Thank you.
All right.